Thanks, Jared. I'd like to welcome everyone, our International Board of Advisors who are here to celebrate the career and scholarship and immense contributions of Linda Carter, not just to law, but to McGeorge School of Law in so many ways. There are students here, they know the contributions you've made to their lives. There are scholars here, they know the contributions you've made to the scholarly discourse, and I think it's fabulous. I want to note that my understanding, at least, my predecessor, Elizabeth Rinskoff-Parker, an expert in international and national security affairs, really energized the faculty to think about international components. We had a long-standing program in Salzburg. We had always been an international school, and what I love about Linda's career is it seems like McGeorge fostered your career, then you became part of the McGeorge that has fostered so many other people's careers here on the faculty, and that's really wonderful, and that legacy will continue. I just want to welcome everyone. Cassandra Fernandez was greeting you out at the table. She is incredible. If you need anything, please just speak with Cassandra. She will make it happen. I want to thank Jared Wong and Omar Dejani, who are the co-directors of our Global Center, who are the primary sponsor along with our law review, because these proceedings will be published. So thank you to the Pacific Law Review and the leadership who is making that possible. Without further ado, I think I'm going to turn this is the introduction of the introduction of the introduction. I will turn the floor back over to Jared to introduce my good friend Chris Blakesley. I was colleagues with him at UNLV, and it's great to have him back at McGeorge where he began. So Jared, why don't you kick off the proceedings? So welcome everyone.
Thank you very much, Jay. So we have the pleasure of having Chris Blakesley present the keynote. Today he is the Cobeaga Law Firm Professor of Law at UNLV, and as Jay mentioned, he was for a time here at McGeorge, but we lost him to UNLV. We did repay the favor, however, by claiming Jay and Raquel, so maybe we're even at this point. In any case, Chris Blakesley is also the Barrack Distinguished Scholar. And in addition to having worked here and at UNLV, he was also the Sanders Chair of International and Comparative Law at the Louisiana State University Law Center. Without further ado, I'm going to invite him up here to give the keynote. Please give him a warm round.
Well, this is really nice and a pleasure for me to be here to participate in honoring Linda, and what a great group of panelists and speakers. It's something I really look forward to. I have a hard time figuring out how to cover the bases in the short time that I have, but let me just I guess try to get the audience worked up and ready to ask hard questions to the panelists when they come up. Not to me, but to the panelists. I'll begin with what's in the brochure, a poem that I think sets up the reason why it's so important to have an international criminal justice system. Epitaph of a Tyrant by W.H. Auden. Which I love. I might read a couple of his, and I think it sets up what for me is the mood, or ought to be the mood, for any discussion about how international criminal law, international criminal justice, the international criminal courts are much more than international abstractions. Frankly, I think international criminal law, comparative law, which goes into it obviously, are verbs. They're actions. And they're also something that manifests, our attitude towards them at least, manifests who we are personally. And for we academics, or we practitioners, or we judges, manifests who we are as human beings. And so for me, it's always been much deeper than the pedantic stuff that often goes on in academics and elsewhere. So let me just read this poem and maybe a couple of others that are brief. Perfection of a kind was what he was after, and the poetry he invented was easy to understand. He knew human folly like the back of his hand, and was greatly interested in armies and fleets. When he laughed, respectable senators burst with laughter, and when he cried, little children died in the streets. That poem has always resonated with me and motivated me for my teaching, my writing, and much of what I've done in my life. It really presents the pathos, the ethos, maybe even the logos of what we're all about. It also reflects Linda's work. Her books, the one coming out shortly, and the one from 2013, wasn't it, with Fausto, represent a lot of the questions that impact or are impacted by this set of ideas and set of mores, and present them in a concrete, practical fashion to improve maybe the world and at least each of us who reads them. Here's another one. For Linda's work, I found this little poem by Lao Tzu, which I think reflects on her and what she's done. Watch your thoughts, they become words. Watch your words, they become actions. Watch your actions, they become habits. Watch your habits, they become character. Watch your character, it becomes your destiny. And Linda has well set up her destiny, although she has much more to go. Another quick poem before I get into a little bit of some of what the panels will be discussing. Another by W.H. Auden. They never forgot that even the dreadful martyrdom must run its course. Anyhow, in a corner of some untidy spot where dogs go to go on with their doggy life, and the torturer's horse scratches its innocent behind on a tree, only God can tell the saintly from the suburban. Counterfeit values always resemble the true. Neither in life nor in art is honesty bohemian. The free behave much as the respectable do. Again, for me, it tells me the dangers that face me as a human being in terms of what I might become if I accept one or another practice, and what I need to fight personally in my writing in the feeble way that I can. Let's see, one final. Violence shall synchronize your movements like a tune, and terror like a frost shall halt the flood of thinking. Barrack and bivouac shall be your friendly refuge, and racial pride shall tower like a public column and confiscate for safety every private sorrow. We certainly, at least I personally, can feel this as this lovely election period takes place at this moment, and I felt it in the past as good friends, very good friends of mine, have facilitated torture. And I've had to face relationship of having been a longtime friend of a torture facilitator, which has pained me deeply. As for the panels, I think they, actually, if you read Linda's biography, what she's done really provides answers and manifestations of what will be discussed and answers to a whole lot. Structural foundations, barriers and obstacles. I wrote an article years ago, I think in '94, for the Fletcher Forum on obstacles to the creation of a permanent international criminal court. And the obstacles and serious problems that face this court, the court that exists now, I think I signaled them a little bit. I was more prescient than I ever thought I would be. I mean, I look back for the first time and saw that. But certainly, as these poems reflect, we as human beings, whoever we are, owe an obligation to those who are victims of such horrific violence. And at the same time, we owe an obligation to make any prosecution of the perpetrators of such violence efficient and fair. And obviously, some of the problems in the International Criminal Court, and in any court, I'm sure, come from the difficulty of balancing justice and fairness. And politics gets involved in the resolution of some cases, situations, as we know. The creation of the court, obviously, given those of us in the United States, we certainly know this. Its creation wasn't accepted or acceptable, I guess, to many or a lot of nations. Certainly all of the Southeast Asian countries are not part of it. The United States isn't part of it. And the fact that that split exists and that the refusal to participate exists is tremendously problematic and presents a sense, I think, of unfairness, political manipulation. As you look at the cases that have been before the court or are currently at the court, what, 1 out of 9 in the ICC is not dealing with Africans? Not that African perpetrators of such horrors shouldn't be prosecuted, but that everybody, that we, each of us, isn't outraged and trying to do something about the fact that no Americans, no Westerners, basically, have been sent. Our political system works for us to deny the possibility that horrific torturers, perpetrators of mass crimes don't go. Well, that certainly creates an impression of unfairness and political manipulation, which is a really terrible difficulty, it seems to me. And a resolution of that is going to be necessary if it's going to function. Now, I dare say it's always sort of been like that. The bombers of Dresden weren't prosecuted, obviously, in the Nuremberg trials, although the Nazis were. The Tokyo trials took place, of course, but no Western groups. Hiroshima and Nagasaki was left out. So that's always been a problem, but it's a problem of the powerful still taking action against either the defeated or those easy to get a hold of, which I guess is a traditional problem of any criminal justice system. But something that we as academics and practitioners in the arena need to fight against and try to solve, and that's what certainly Linda has done in her writing and in her work for the courts. We really have to do that and find a way to make it something that is truly international and that doesn't have a pretense or a manifestation of bias against or for any group or nation. I also want to add just one little thing, because Linda wrote so much about it wonderfully on gacaca and the dispute resolution mechanisms. I think it's a fascinating question about whether such mechanisms ought to be a parallel universe, so to speak, or part and parcel of the entire system if one ever develops. And we need to think about that as well, and I know a panel will be discussing it, as well as the comparative and the comparative law, comparative procedure aspects or troubles, problems, barriers that face international courts. Since we all come from various systems and have our own culture, our own language, our own conceptualization of words, phrases, systems, structures, even using the same word is often problematic and poses dangers. I've mentioned this story before, but when I was in the State Department, there was a case, the Willie Holder case, a hijacking, and I was just a young whippersnapper. And Willie Holder hijacked a plane from San Francisco, ended up going to Algeria. And then for a long time he was just missing, 20 years or more. And then finally, when I was in the department, a cable came through from France saying, hey, we have Willie Holder. He is in a mental hospital down by Avignon. And so we sought his extradition for hijacking. He ended up not being extradited, but just as an example of the problem that Linda and Judge Pokar focus on a whole lot in their work is that the importance of comparative understanding, almost linguistic in its deepest sense understanding of the terminology and the workings of the criminal justice system. In the treaty, of course, like every extradition treaty, it provided for the obligation to extradite perpetrators of crimes. And in French, the phrase, the clause, was les parties ont l'obligation de représenter la partie dont ils ont promis de représenter. The obligation to represent, same word, the other party to the treaty exists, okay? And while I was in the State Department, I knew this because I'd spent so much time in France, but my bosses used their conceptualization of represent was an adversarial representation. So we go to the extradition hearing before the Cour d'Assises, and of course we were just advisors, but the avocat général gets up and he presents all our evidence, which was his duty to represent us. He presented the evidence and then proceeded to argue, his plume being libre, that Willie Holder should not be extradited because what he committed was a political offense. And my bosses were outraged, and it made me even write, I had to even write a diplomatic note, which I wrote with tongue in cheek, but did indeed write it, you know, in protest, saying that you breached the treaty when indeed both sides were correct about the term. Represent meant represent, and it meant different things to them. The obligation of the avocat général was to find his objective truth, so-called, and to present the evidence, but to try to do justice in making his proposal. And Willie Holder was not extradited. So, sorry for going on maybe a little too long, but I hope y'all got worked up. Thank you very much.